Hello, everyone, and welcome to the Rental Housing and Unlawful Detainers session with our speaker, Jeff Hearne. Just a couple of announcements before we get started. Jeff's presentation will be in the session files after his presentation, and you can find that on the FeedLoop platform, just going to the session, and you will see, if you scroll down, you'll see a tab that says session or says files, and you'll be able to download it there. If you want to use the closed captioning, that is right underneath the screen on FeedLoop, and you just click on that. You'll see the closed captioning and the box below it. So welcome today. Our speaker, as I said, is Jeff Hearne. Jeff is the Director of Litigation at Legal Services of Greater Miami, where he's worked since graduating from law school in 2001. Jeff oversees the firm's significant litigation and provides a strategic focus to the firm's advocacy in all its practice areas. He previously served as the Advocacy Director for the Tenants' Right Unit and is the Director of the Tenants' Right Clinic at the University of Miami School of Law. He currently serves on the Florida Bar Civil Procedure Rules Committee and is a former co-chair of the Florida Housing Umbrella Group, the statewide association of tenant advocates. He's received several honors for his work, including Consumer Protection Lawyer of the Year from the Consumer Protection Law Committee of the Florida Bar, the Housing Justice Award from the National Housing Law Project for his successful and dynamic pursuit of housing justice for people most in need. He's a graduate of the University of Texas at Austin. So welcome, Jeff, and thank you for joining us.
Thanks, Kathy. So I was asked to speak about unlawful detainers and rental housing issues, which is a very broad category. And I understood that there was a lot of interest really on the unlawful detainers and sort of how you deal with somebody who is in this middle ground between a tenant and isn't really a tenant under the law, and how do you deal with it. So we're going to spend a lot of the time really talking about unlawful detainers and the process that exists to remove somebody who's in the household who's not wanted there. And then when we come to sort of rental housing issues, I want to sort of focus on, the topic that sort of everyone's talking about right now, or the gigantic rent increases that are happening across the state, and just talk a little bit about some of the policy solutions that people are putting forward across the state. So we're going to start with the unlawful detainer, but before we do that, we really need to talk about what a tenant is. So we'll go through that, talk about the different ways that you can remove a non-tenant, and we'll also speak about, like I said, the rent increases across the state. So I think this is the common scenario, and for those of you who represent elderly individuals, we see this fairly commonly, right? You've got a woman who has a grandson living with her. He's not contributing to the household. He's staying there. Maybe he's got a room, and the grandmother can't keep up on the bills. He's eating food and using electricity, and the grandmother's fed up and wants the grandson to move out, but he won't. And what do you do in that situation? So that's really what we're talking about here, are these murky situations, at least legally, about what is the status of this person who is living with the elderly individual. And I do want to say, I forgot to mention at the beginning, if you have questions, please put them in the chat, and we'll try to address them as we go along. That's one of the downsides to this format, is we don't have as much interaction, but I'd like to make it as interactive as possible within this format. So when we're trying to figure out if somebody is a tenant, we firstly look to the Florida's Residential Landlord Tenant Act, which is in Chapter 83, Part 2. And the statute says that it applies to the rental of a dwelling unit, which isn't, particularly helpful guidance there. And so what we have to do is we've got to break that apart and look at sort of the definition of each part of that definition. So we start with a tenant is someone who is entitled to occupy a dwelling unit under a rental agreement. So the first question is, well, the dwelling unit, this person who is staying with his grandmother is, living in, he's got a bedroom there, but he's not, occupying the entire house. That's okay. Under the statute, under Florida Statute 83, you can still be a tenant even if you're renting a bedroom, because it's very specifically says that it can be a part of a structure. So the question is, is there a rental agreement? So a rental agreement is any sort of agreement to use and occupy a dwelling unit, and that includes oral agreements. And what we typically see, and it's very rare, you have a situation where a grandmother asks their grandson to sign a lease before they move in, or some sort of written agreement. So it's almost always an oral agreement. So the person still could be a tenant. The grandson still could be a tenant. So the question is, did they, were they paying any rent? And rent is periodic payments due to the landlord for occupancy under a rental agreement. So you sort of have to look at, was he supposed to contribute? Did he ever contribute anything? And in a lot of these circumstances, there is no sort of formal rental agreement. So there is no formal rent. So they are not someone who is covered under the statute. But you're going to have to really analyze this if you're trying to figure out if someone's a tenant by looking at the facts and applying it to all of these definitions to see if you can figure out, can we make the argument that the person who's living with the elderly individual is a tenant. So if the grandson was a tenant, the tenant has to be evicted. The landlord, the grandmother, has to go through the eviction process. So, most of you probably are familiar with that, but before a tenant can be evicted, the landlord, in this case, it would be the grandmother, would have to send a written notice to the tenant, to the grandson, saying that their tenancy is terminated. There's lots of different types of notices that can be sent to the tenant. If they're behind on rent, it has to be a 3-day notice. If the grandmother just says get out, right, as a tenant, they only have to give 15 days notice in most parts of the state. And then obviously if the grandson had done something and violated the rental agreement in other ways, the grandmother would likely have to give a 7-day notice. So that would be the first step. They'd have to give her a notice. And then the grandmother would have to file an eviction in county court. That's a separate lawsuit. And one of the, and that would proceed obviously, but one of the, I guess, benefits to the grandmother, if she was required to file an eviction, is that then the tenant would have to deposit rent with the court. And I know most of us, including myself on this call, is usually in the situation where we're representing the tenant, right? We're representing the person who is being evicted. And the obligation to deposit rent is one of the great frustrations we deal with, because it often keeps the tenant from having their voices heard and from being able to raise potential defenses, getting their day in court. But if you are representing the grandparent or the grandmother in this situation, there might be a benefit to being seen as a landlord, if it actually was a landlord-tenant relationship. So if you're dealing with somebody in this situation, you really got to look at those facts and figure out, is the person a tenant? Is the person some other occupant? So let's say we've just decided, there was no agreement with the grandson and the grandmother. There was no rental agreement because he never paid anything. There was no agreement to rent for him to make periodic payments to the grandmother. Then we've got to go to another part of Florida law. So Chapter 83, Part 2 is the residential eviction statute, or residential landlord tenant statute. Chapter 82 is where we find the other causes of action to remove somebody for the owner of property or somebody with the right to occupancy of the property to obtain a judgment for possession. There are sort of three categories. Really
Jeff,
four.
can
Yes.
I ask you, you got a quick question right now. The question is an assisted living facility resident considered a tenant?
I would say in most cases, they are not going to be. There is an exception in Chapter 83 that says if the residence is incidental to medical services, then they are excluded from the landlord-tenant statute. But I would say you should always review the agreement between the ALF and the person living there. I just note this because recently there was a second DCA decision. It was a case involving an ALF and an occupant. I'm not even sure what the underlying issue was, but the issue that went up on appeal was whether an arbitration agreement in the contract was enforceable. And that arbitration agreement excluded evictions from the arbitration process. So I don't know, maybe that agreement, perhaps that ALF resident is entitled to have the eviction process. But I would say in most cases, there's probably a better argument for the ALF to say, hey, we're excluded from Chapter 83. And my understanding is that that's probably the process, or is that that's the position of most ALFs. But I don't have a lot of experience handling ALF issues. Okay, so there are three sort of categories of situations that are sort of defined in Chapter 82. Two of them really aren't sort of applicable to this. There's something called forcible entry or unlawful entry. Forcible is entering by force. Unlawful entry is when somebody enters into property without any authorization. So I'm not going to spend much time talking about those, but the third category is the one that is more relevant to the fact patterns that we're used to, unlawful detention. And that is defined as possessing real property, even if the possession is temporary or applies only to a portion of the real property. So that would be having a room in a house, right? Without the consent of a person, or after the withdrawal of consent by such person. And that really is the scenario that we see, right? The grandmother gave consent to her grandson to stay there, and now she's withdrawing that consent. These definitions are found in Chapter 82.01. And I will say that in 2018, there was a major sort of rewrite of this chapter. So make sure you're looking at the current version. I mean, the older version still talked about entering into lands with multitude of people and things from back when we were more agricultural states, but it's sort of been modernized now. So make sure you're using the most current version of the statute. And so the statute also says that the person entitled to possession has the right to sue for possession and damages. Okay, so it's not just possession, they can sue for damages. And explicitly, residential tenancies are excluded. So that gets us back to the questions we were asking before. You've got to make sure that the person that is going to be the defendant, that the grandson is not a tenant, or else you brought the wrong type of lawsuit against the grandson. So I'm going to focus a lot now on an addition to the statute in 2015 that is really designed to try to deal with these sort of murky middle grounds. And what the legislature did in 2015 was create an unlawful detention by a transient occupant of residential property. And it defines a transient occupant as a person whose residency in real property has occurred for a brief length of time, isn't pursuant to a lease, and whose occupancy was intended as transient in nature. So if we're thinking about this in the context of the grandson moving in with the grandmother, maybe you need to know a little bit more information, right? So how long have they been there? Do they have a lease? Or presumably they don't have a lease. And then, what was the intent when the person moved in? It's a little hard to sometimes figure that out because obviously situations change. But if the grandson was a transient occupant, then the grandmother has the right to tell that person, to leave. And if the grandson does not leave, then they have unlawfully detained the property. That's where the term unlawful detainer comes from. And the legislature stated that it created this provision because it was recognizing the right to exclude others as one of the most essential components of property rights. I guess they just the legislature wanted to make clear why they were enacting this provision. The statute also gives several factors to figure out whether somebody is transient or not. And these are not sort of exclusive factors, but these are just a list of things that can be looked at. So first thing is that the person doesn't have an ownership, financial, or least interest in the property. Obviously that would, if the person had an interest to be there, that would change the analysis completely. Do they have any utility bills? Obviously, if somebody is not transient, then they are going to sort of be receiving bills at the property. They may have, water bills, electric bills, phone bills. Another factor to consider is whether they can produce any sort of documentation, correspondence, or ID cards from a governmental agency showing that address in the past 12 months. And the examples that are given in the statute are, motor vehicles or elections, a voter ID card. So if you got that within the last 12 months, then perhaps there was no intent for the person to be transient. Paying minimal or no rent. And I find this is sort of an interesting factor because this suggests that somebody could be paying some amount of rent and they could still be considered transient. I would suggest that runs afoul of Chapter 83. And if the individual is paying rent, even if it's minimal, they are a tenant, and the landlord or the grandmother would have to file an eviction action. Next factor is, do they have their own space at the property? We had that photo before of somebody sleeping on the couch. Perhaps that's a suggestion that it is transient because they don't have their own room, they don't have their own space. That's another thing to look at. Also, do they have any of their personal property there? If all of their personal property is in storage and they're just staying on the sofa, that seems more likely that there was an intent for the person to be transient and it wasn't intent to be permanent. And then the last factor that's identified by the legislature is that the person has a permanent residence elsewhere. Of course, that would suggest that they do have a home and that this was just a temporary stay. And then the statute has this one sort of note that it adds is that minor contributions, contributions to the household, like paying expenses, do not establish residency. I think what's important is that there's not just like one of these things alone that says that somebody is transient. You sort of have to look at the total picture and look at all of the factors. And there could be other facts that aren't on this list that could dictate whether somebody is a transient occupant.
Jeff, question. What about somebody who really moved in there because of COVID, maybe a lost job or something, with the understanding the parent, let's say, thought that it was just during COVID, and they say they changed their address from the old place that they moved out of to the new place. But still not paying any rent, but maybe they went back to their old, childhood bedroom. Would that be transient, or what do you think?
Yeah, I mean, this is what's so interesting, and I'll tell you that there have been no cases that I can find that have involved this statute at the trial court level. There's none reported in Florida Law Weekly supplement, and then there's none up at the District Court of Appeals. So, who knows? I mean, I think these interesting fact patterns, and that's sort of what's coming next on here, is like, well, let's first start with that scenario that I put forward at the beginning. Is this person a tenant? Is this person transient? And I also like to just remind you that there's also, somebody may not be a transient occupancy, but they may not be a tenant either, right? So the statute that the legislature created in 2015 is really about this transient occupancy, and we're going to talk about some other sort of rights that come along with that if the person is a transient occupant. But there is this sort of other category of people where it's not a landlord-tenant relationship, but the owner must go and would still have to file an unlawful detainer against the individual. So I don't know that we have enough facts in this scenario, but I think this person is probably, clearly is not a tenant, because it doesn't sound like they ever had any agreement to make payments. And I'm going to get back to you, Kathy, in just a second on the COVID question, but but let's change this scenario a little bit. What if the grandson has lived there for 10 years, never been paying rent, never been really contributing? Can the grandmother just say, get up and leave? Now, I do not believe that obviously somebody can't be a transient occupant if they've been there for 10 years, but just the fact that they've stayed there for 10 years doesn't turn them into a tenant. The grandmother could still use the unlawful detainer process to remove them. What if they live there for 2 months, but the ID is the address? And that, let's use Kathy's example there. The person moved in during COVID and started changing things. But let's say we're 2 months in, and the family member is like, this isn't working out, you need to leave. Is 2 months transient? What was the intention when the parties moved in? As a lawyer, I mean, it sort of seems like, well, if you're counseling someone and you're in one of those rare situations where you're on the front end of the problem, right, where maybe the grandmother is considering this arrangement, I think there's a lot of benefits to trying to formalize it and put it into writing, exactly what the arrangement is. I know that that's probably overly lawyering it, and most people would never do that, but there is a benefit to it because it's clear. But we do know that things change over time. What might have been the intention when the person moved in, it might have changed. I tend to think the statute does not really give any definition for what transient is. They throw some, 12 months is thrown out there in context of the ID, but I think you could argue that somebody was transient if they were there for 2 months. Now, what if the grandson gave $250 each month to the grandmother to help pay for expenses? The statute's pretty clear that saying that these sort of like minor payments, minor contributions, don't establish residency. I think that what's the definition of minor? It's a little unclear. $250, perhaps that's minor. It's not a huge amount of money each month. But as that number goes up, what if it was 500? Is that minor anymore? So, I think the takeaway from this is that you really have to look at the facts, and then you just got to argue for your client's position based on those facts and looking at those factors. So if the grandmother and grandson relationship is a transient occupancy, then the statute says that the person with the rightful ownership can file the action for unlawful detainer under 82.03. The statute is very explicit that the person does not have to notify anyone before filing the action. So grandmother doesn't need to send any sort of written notice to the grandson. They can just go straight to court if they've revoked the authorization to be there. I would suggest, I think I'll make this point later in the PowerPoint, that while the law may not require any sort of written notification, it's probably a good idea to actually send written notification, because that way there's no question over whether the authorization to been there to live there has been revoked. And it gives you something that can be attached to the complaint as well. So the statute also says that if the court finds the person is a tenant, then the plaintiff must be given an opportunity to provide a notice of termination of tenancy under Chapter 83 and then amend the complaint before dismissal. So if you're representing the grandmother in this situation and you're sort of on the fence, is this person a temporary occupant? Are they a tenant? You may, it's sort of no harm, no foul if you file under Chapter 82, because if the court finds that they're a tenant, then by law, the grandmother would have the opportunity to amend and turn it into an eviction case after giving proper notice. Now, I will say that one thing you got to be careful about is that this provision is only in the temporary in the statute that is for temporary occupancy. If the grandson is in this, not a tenant but not a temporary occupant, the homeowner does not have a clear right to amend. That is only in the provision around temporary occupancy. So you may want to be careful about that provision if you're trying to make a call on whether the person is a tenant or just some other occupant in the property. So this is the big sort of reason why somebody might want to have someone be deemed a temporary occupant. This was the big change. And the legislature said, one of the reasons that the legislature enacted this provision was that they recognized that it costs a lot of money to go through the unlawful detainer process. And they wanted to create some sort of quick mechanism to have someone removed. So there is a provision in the statute which says that if the grandmother has somebody, wants to get rid of somebody who's under who is a temporary occupant, they can provide an affidavit setting forth the facts, including all of those factors we listed, establishing that the grandson is there under a transient occupancy and has stayed there after the grandmother has requested that they leave. If that person does not leave at the direction of law enforcement, they can be arrested for criminal trespass. And there's some very interesting things in here that I, as somebody who believes in due process, seems very problematic. So if somebody gets prosecuted for criminal trespass under the statute, the state doesn't even have to prove that the person was a transient occupant. And if the criminal defendant now says, look, I was actually a permanent resident there, that's not even an affirmative defense to this arrest, which is kind of shocking to me. I can't imagine that would stand up if ever challenged, but that's what the statute says. And if you're somebody, let's say you're representing the grandson who was wrongfully removed under this process by law enforcement, the grandson would be authorized to sue his grandmother who signed this affidavit, which was, incorrect. But he couldn't sue the police department for removing him unless they acted in bad faith. So, we don't do this a lot in our office. We've had on occasion through our elder grant have filed some unlawful detainers. And in one situation, we did try to provide an affidavit to law enforcement. And honestly, our law enforcement was, they were like, we're not touching this. This is a civil remedy. This is a civil dispute and you need to go to court, which was always sort of the message before the statute was enacted. In fact, that's what the legislature says in its legislative analysis, that they're trying to avoid that sort of response from law enforcement. But at least I can speak for us here in Miami is that the one time when we have tried to use this in a situation, we couldn't get law enforcement to actually rely on the provision. Okay, so the next thing I would just say is that there is a very detailed part in the statute around this temporary occupancy that talks about what should be done with personal property that's left in the unit. Essentially, that the transient occupant has to go and collect their property within 10 days. Is what the legislature has said is generally reasonable, which seems kind of like a long time to me, but that's what the statute says. And the grandmother can impose reasonable conditions on when the person comes back. And if there's any sort of misconduct, whether it's like damage, abuse, or theft, history of violence, drugs, alcohol abuse, then the owner can request the presence of police. A licensed mover is in the statute. It's a little strange. I guess it means the owner could hire a licensed mover to remove the property, or could have a trusted third party there. So what they're clearly trying to get at is to protect the individual, assuming it's the grandmother, that if there is really sort of a threat to the person, then they can impose more restrictions on when that person comes back to get their property. And once again, if this transient occupancy statute provides for a cause of action for the person to sue if property is wrongfully withheld, and there are prevailing party attorney's fees and costs if that lawsuit is filed. Okay, so what does it look like if you file an unlawful detainer? It's pretty simple. This is just an example of what it is that the person withdrew consent and requested that the defendant vacate the property. They didn't, they stayed there, and that the plaintiff really should allege that it's not, that the person is not a tenant, and that there's no landlord-tenant relationship between the plaintiff and defendant. So it's very simple. I would say that if you are going to file one of these on behalf of someone and you are going to rely on the transient occupancy, I would sort of amend that. I mean, this is very similar to the form that's in the rules of civil procedure. But if you're going to do a transient occupancy unlawful detainer, really list out the factors and identify everything why the person really is a transient occupant. Okay, so you drafted the complaint, you're ready to file. One thing that's sort of that we've at least seen some issues with is that, if you're filing the lawsuit, you've got to pay the filing fee. Many of our clients are indigent and are eligible to have that fee waived, but I will tell you that it confuses the clerks a lot because typically the plaintiff in eviction cases is not indigent and is not eligible for indigency affidavit or fee waiver. So just just be aware that you might have to sort of finesse that through the clerk's office when you file these, if you're relying on an indigency affidavit. As I mentioned before, I really would highly encourage you to send notice, even though it's not required under the statute. I think for two reasons. One, having something attached, it's very clear that the consent to be at the property has been revoked, something that can be pointed to. And then also just from sort of a fairness due process point of view, it's important to put people on notice before the lawsuits are filed. So I would recommend that you still do that. Even if it's a short period of time, at least the person received some written notice before the lawsuit was filed. So just like in evictions, 2 attempts at personal service, then after that, the summons can be posted at the property. There is one difference here, that if the plaintiff anticipates they will serve by posting, then they have to provide 2 envelopes to the clerk, one to the residence and one to the last known business address. And the clerk is supposed to mail those out. I don't know if the person doesn't have a business address, probably provide 2 envelopes with the home address, but that's what the statute requires. The unlawful detainers are also filed under summary procedure. So the person who's the defendant has 5 days to file their answer. Just like in evictions, limited discovery, it's supposed to be advanced on the docket. And then, in a lot of these cases, just like in evictions, the defendant doesn't respond. If that happens, the grandmother could file a motion for default because there's no answer. And of course, if you're filing that motion for default, you've got to attach a non-military affidavit as well. One of the big differences with evictions is that there's no requirement to deposit rent like in evictions. So if the person answers, if the grandson actually files a response as to why they shouldn't be removed from the property, there is going to be a hearing or trial because people aren't defaulted, right? Which I, go a little bit up on my, go off on a little bit of a tangent here, but it is sort of interesting that somebody who has even less occupancy rights has a right to a hearing, but somebody who is a tenant and is renting property does not have a right to that hearing. But I'll get down off my soapbox. So, there's going to be a trial where the court will determine whether the person has a right to be an occupant there or not. And if the court finds that the person stayed and it was willful and knowingly, then the court must award damages equal to double the rental value. So there would have to be some sort of determination about what the actual rental value for either the room or the property that they're staying in is. This is not really addressed anywhere in the statute like it is in Chapter 83, but in most cases, the law is that you need to have personal service in order to award damages. So if there was only posting where the landlord put the summons and complaint on the property door, bedroom door, wherever it was posted, then likely they're not going to be able to get damages against that individual. Statute does say that they can be separated. So, many times, if you're representing the grandmother, let's say you are going to be able to get damages, and maybe there's a reason you want to, but that's going to take more time, more proof. You can separate out the two claims, and the action for possession can be tried on its own. As I mentioned before, if the court finds that the defendant is a tenant, if this is just a regular unlawful detainer, then that case could be dismissed, or the court could rule for the defendant because the defendant's a tenant. However, in the transient occupancy cases, then the owner, the plaintiff, will have to be given an opportunity to amend and turn it into an eviction case. So if the plaintiff, in this case the grandmother, prevails, then the court will enter judgment for possession. They can also enter the judgment for damages and costs, and then the clerk will issue the writ of possession, which will then instruct the sheriff to remove the individual from the property. I will say I have filed one of these, and we had a fee waiver in the case, and we had a client who was indigent, had no money. And it was a little bit of a struggle to get the sheriff to realize that fee needed to be waived as well. But it is a cost that is covered under the indigency affidavit. Then, of course, if the defendant prevails, the court would enter judgment in favor of the defendant, the occupant. And if that happens, then the plaintiff is potentially liable for costs, not for attorney's fees, but for costs. So there may be some other options. We've talked about an unlawful detainer. If there is a potential claim for title with the person who's living at the property, then it wouldn't be proper to file an unlawful detainer. The plaintiff would need to file an ejectment action in circuit court saying, I've got good title, I've got better title than the other person, and to have them removed. Another potential option, if you're having exploitation of a vulnerable adult, is the injunction to deal with this exploitation. I know Ellen Cheek is going to have a presentation later this week, and she's going to go into more details about that. But if the elderly individual is eligible for that, you may be able to get removal of the person through that injunction. And then, of course, if there is violence, a domestic or repeat violence injunction may be another way to get to remove the person from the household. But it's really important that the plaintiff or the petitioner in that case meets those standards. I know that our judges who sit in domestic violence court often find that people are improperly using the domestic violence injunctions to remove people who should be removed through another method, through unlawful detainer or through eviction. So you obviously don't want to go down that path.
And Jeff, one question about that, it says, we always have our clients bring a copy of the approved indigency waiver to the sheriff, then they go for the rent, or when they go for the rent. And that solved the issue for that organization.
Yeah, no, I think that's definitely a good practice. I was in the situation where I had it in hand, and we're still saying, well, we just don't do that. So it's, especially if it's the first time, right? A lot of times when we're doing things that the bureaucracies are not familiar with, it takes a little bit more hand holding. And hopefully once you've convinced them the first time that this fee can be waived when we've got an indigency affidavit, then you won't have problems the next time. But I'm glad to hear that it's working for Pamela in her jurisdiction without any problems, because that's the way it should work. Okay, so before we move on, any further questions about unlawful detainers? Okay, see, just curious, what happens if the tenant has a power of attorney? I assume you mean where let's just say the elderly grandmother has given a power of attorney to the person who is living in the property. Yeah, so I mean, if I was advising that individual, I think probably as part of the process, you might, it would probably depend on the scope of the power of attorney, but perhaps, if this is somebody they don't even want in their household anymore, they might also want to revoke that power of attorney as well, because it does sort of send mixed messages. But, every situation is different and has to sort of be analyzed based upon the facts of that case. So I'd want to really sort of know more about the situation, if I was advising that client. Any other questions before we move on? Okay, well, we are going to talk about rent increases, because this is what everyone everywhere, really in the country, but especially in Florida, is talking about these days. We've all seen it in every location. I mean, this headline from a month ago was showing that our three big cities were showing the largest increases in the country, right? And sort of how do we deal with that? And so many of our elderly clients are on fixed incomes. And unfortunately, I don't have a lot of great answers here, but what I sort of want to go through is some of the policy ideas that have come out and are being discussed. And then I want to highlight sort of a particular problem that we see for some of our clients. So I can talk about what Miami-Dade has done. About 2 months ago, they enacted what we call a fair notice ordinance, which says that if a landlord is going to increase the rent more than 5%, they have to give at least 60 days notice. Now this doesn't sort of prevent that rental increase from happening, but it does give somebody more time, a tenant more time to figure out if they can stay or not. So while I wouldn't call this necessarily a solution, I think it obviously provides more time, the more time somebody has to prepare for something, the better. I also think it sort of sends a message that, if you want to increase the rent less than 5%, perhaps you're going to have some landlords who sort of stay under that so they don't trigger any notice requirements. But I haven't seen that play out yet, but we'll see how this works over the next year or so. One way that Miami-Dade also dealt with this is they have included rental increases as part of our rental assistance program. They aren't using the emergency rental assistance funds to pay for these increases, but they have a pot of money that they're using. Unfortunately, that doesn't really solve the underlying problem. At some point, that money is going to run out. It's only for a few months. It only gets the tenant so far, but it is sort of one way to sort of alleviate the immediate increase right away. I know that at least in Miami-Dade, and I believe in St. Petersburg, I've heard as well, there's been some discussion about right to counsel, to ensure that tenants who are potentially facing loss of their home have a lawyer by their side. And I think as you see sort of these more extreme actions taken by landlords, you will continue to sort of see this right to counsel be talked about in more serious terms. It has, I believe there's 18 local jurisdictions that have it now in the country and 3 states. So there definitely is a trend towards enacting some form of this across the country. Okay, so to give a break from me, listening to me talk constantly, I'm going to show a clip. This isn't from Florida, but it was from fairly recently in Georgia. And I think a lot of us think, well, one of the solutions to these rent increases is let's just get people into affordable housing. And then we don't have to worry so much about rent increases. So let me stop my share. Let me do new share.
The apartment complex that she calls home. This comes just after her rent was raised just a few weeks into her lease. Brittany Miller worked to get to the bottom of this increase, as the management company claims it's the government who's responsible for it.
I feel like a failure to my kids. I feel just like a disappointment. I feel like they just made friends. They just got into school and got adjusted, and now I'm ripping them away from this place too.
Caroline Gray is being evicted.
Really disappointing, because this was supposed to be a place that was made for low-income families, and it's not.
Gray lives in Robbins Landing Apartments in Warner Robins with her husband and 3 kids. The complex is considered low income and receives government funding through the Low Income Housing Tax Credit Program.
We moved back here because my mom lives here. I have help with my kids, and I thought it would be cheaper, and not so.
Gray and her husband say they signed on initially to pay $1,066 in rent every month, but now, just 2 months into their lease, that price has shot up to $1,230. That's more than $150 more than what they agreed to.
There's no way that I would have agreed to live here if I knew this soon into my lease, I would be jacked up.
Days ago, Caroline got this letter on her door explaining that her rent is based on the United States Department of Housing and Urban Development's area median income. And if that income changes, so can her monthly rate, with just 30 days notice.
And I'm not making any more. So
HUD reevaluates area median incomes every year, but according to the department's website, they don't require or suggest rent increases. They only set the maximum price landlords can charge. During my interview with Caroline, the property manager of Robbins Landing interrupted, asking if we were discussing the property. So I asked her for a comment on the rent increase. She said it's out of her control, telling Caroline and I that the new price came from the government.
if you're gonna increase the rent like this, do it at the end of the lease. Do it during renewal time, so I have the option to say no and leave. Leave correctly.
Caroline and her family chose to not pay rent this month, allowing them to save enough money to find a new place before the rent goes up on June 1st. But with worries that a new affordable apartment may not exist, she's considering an alternative.
There's an RV lot in Byron that's $450 a month. and it seems like quiet and nice. It's sad that I have to resort to a camper because I can't get in anywhere else around here.
Reporting from Warner Robins, Brittany Miller, WGXA News.
Okay, so unfortunately, what that woman in Georgia is experiencing is what a lot of people here in Florida, who especially elderly individuals who are living in low-income housing tax credit properties, are facing. So if you're not familiar, these types of properties really are the largest form of affordable housing that is being developed. And unlike other types of affordable housing where the rent is based upon your income, and if your income goes up, your rent goes up. If your income goes down, your rent goes down. These properties just have rent ceilings. And these limits are based, as the article told you, on the area median income, which has continued to go up. But what we have seen, especially in the elderly housing properties, is that obviously as the area median income goes up, that's going up significantly, but Social Security checks are not going up. So we have seen people who have been living in these properties for decades, who are slowly, maybe their only income is SSI, and they have slowly been sort of priced out of their affordable housing. And what can you do about that? Because the landlord is within its rights to increase the rent because they're under the amount. So it's something to be on the lookout for, because unfortunately sometimes there are not a lot of great solutions. The other thing I want to highlight is this exact same fact pattern that this woman had, is that a lot of the landlords in these types of properties have provisions in their lease which say, we can raise the rent anytime the area median income, that HUD adjusts the fair market rent. And there's a lot of reasons why that just really isn't fair. Unfortunately, they are lease provisions that are often enforced. And I would say that, these properties are regulated through the Florida Housing Finance Corporation. And, there are some states that prohibit this practice, that rents can only be increased at the end of the lease term. But that's not the case here in Florida. So this is something really to be on the lookout for. I will say that, sometimes you do have individuals who may be in units that are designated for extremely low income. So they may be even lower rents, or you might have a client who's lucky enough to have a Section 8 voucher, which would then make the rent be based upon the tenant's income. But then, you're sort of like, we're layering all these subsidies on top of each other. We're not increasing new affordable housing if we're, sort of putting voucher holders into those units. So something to look out for as you do represent individuals. Another thing that's obviously being discussed is the question of rent control. And I see sometimes this being reported in the media as saying that Florida has banned rent control. And that is not an accurate statement, but the legislature has made it very difficult to enact. So in order for a local municipality to enact rent control or rent stabilization, they first have to determine that it's needed to eliminate an existing housing emergency that's so grave to constitute a serious menace to the general public. And I can say that here in Miami-Dade County, our county has taken the first steps to determine whether there is a housing emergency, to sort of take that very first step on rent control. And I think, all of our elected officials, especially at the local area, have been seeing, people being displaced from their communities. And I can't imagine any serious study that could not find that there is a housing emergency in the state, anywhere in the state of Florida right now, especially in our larger cities. So once the municipality is determined that there is a housing emergency, there has to be public notice and a hearing, and where where the rent stabilization ordinance is passed, then it has to be voted on by the public. And this can only last for 1 year. You have to go through all of these steps every year. So as you can see, it exists, but it's really hard to do because of this requirement to take a vote every year. But it's something to look out for. It wouldn't, 2 years ago, if you had asked me, would we ever have a serious discussion about rent control anywhere in Florida, I would have told you you're crazy. But things have gotten so bad that I think that there's going to be some places that actually try to make this happen sometime in the near future. So that sort of brings me back to like, where are we going next? With these rent increases, the sad news is that there really isn't a lot to do to challenge these increases. Maybe if you've got, a really egregious situation, or the landlord didn't give proper notice, perhaps there might be some challenges on a handful of cases. But for the most part in Florida, landlords have the right to set whatever rent the market will bear for their units. Obviously, these increased prices are going to lead to more evictions for people who can't afford the rent, and increased homelessness. And that sort of brings us back to where we started, is that I think we're going to see more family members living together in these situations just because they can't afford anywhere else, which will then probably lead us to more situations where, elderly individuals who maybe own the home in the family are forced to use unlawful detainer to remove somebody wherein the relationship isn't working out anymore. So I hate to end on sort of a not so happy note, but when you're talking about some of these situations these days with the rents going up so dramatically, it's hard to find a silver lining in it. But I think I have hit the end of my period, so I want to see if there's any questions on any of it.
Yeah, there's one question, and it's, does the tenant have the right to end the lease if the rent increases?
Well, so in the tax credit context, you really would have to look at the language in the lease. So if the lease gives the power of the landlord to raise the rent in the middle of the lease term, you would want to see whether the lease also gives the tenant the option to terminate it. I would think that and what we were really talking about was in sort of these affordable housing properties. I would imagine that a tenant who goes in and says they can't, afford it anymore, you would hope that the affordable housing provider would honor that, allow them to break it. But unfortunately, you can't really assume that. A lot of these leases also have early termination fees, right? If you break it early, then you got to pay extra money. So that's something I would really want to look at real closely about the language of the lease to see if there is an argument for the tenant to get out of it if they want to.
All right, doesn't look like we have any more questions or anything in the chat box. So unless somebody sends up something in the next minute or so, Jeff, I want to thank you for being a part of this conference and for your presentation today. Thanks.
Thanks for having me.